Before I begin, I wanted to inform the committee that I have a hard stop at 5 o'clock. My niece is having her first communion, and I was one of the 6 people she selected to attend.
Well, I know there's been some discussion about some medical images of Nikki that were rediscovered in 2018 that had essentially been sitting in a box for 15 years. Does that sound accurate to you?
Yes, we were actually getting ready to start the first hearing, and the district clerk said, "Wait, I think I know where those are." And she literally went and got them, and we were all very surprised.
What other alternative explanations were discussed at trial in front of the jury that could have caused those triad of symptoms?
As I said before, I was not DA at the time, so I was not present during the trial.
But from your review, from your review of the trial and of the medical evidence, what else was ideated upon in front of the jury that could have explained those triad of symptoms? And
yes,
by the
sir,
way, out of respect, attorney, I understand you weren't there. I know you didn't argue the case. You did request the execution date to be set. So I do think it is fair that this committee has some base level expectation of your knowledge of the case. Did the jury in the trial case, again, I'm aware you didn't argue the case, did the jury ever hear any arguments from the defense of actual evidence of the defendant?
Evidence meaning?
Evidence that he did not in fact commit a crime.
I believe that was elicited through cross-examination.
Okay. Out of respect for your time, I'm gonna move on. Has any jury at any time heard any evidence or arguments of the following things? That there was a CAT scan, which I wish we had more time. I would really love the state's explanation for how this medical evidence was somehow missing and disappeared for 15 years locked in the basement of your courthouse. I would love to spend time on that, but we don't have time for that. Has any jury heard any evidence or arguments regarding a CAT scan which does appear, according to expert testimony, to show only one single minor impact site to the head? Was any jury ever made aware of this?
I want to clarify, first of all, if I may, as the committee should know, that once evidence is submitted in a criminal trial, it becomes property of the court, and the clerk is the caretaker of that. It's not something that the state was in possession of as it was entered into evidence. So there was nothing nefarious there by the state or by the defense. I would
appreciate the clarification, but the reason this line of questioning is critically important because the legislature has a question before our committee right now as to whether our extant junk science law is being faithfully adhered to, because there may be medical evidence that is materially relevant to the outcome of this case that has or has not been heard before any jury. So I would just appreciate a response. Has any jury at any point in time ever heard expert testimony on the CAT scan that showed there was only one single minor abrasion or bump on the back of the head?
I would have to refer back to the trial transcript to see if the fact.
You don't know.
I would have to refer back to
Thank you.
the trial transcript.
Has any jury heard any evidence or arguments to show that if shortfalls from beds can in fact be significant?
I believe that was brought up in the original case.
Okay, you think that one was heard. Okay, has any jury heard arguments or evidence that CAT scans and autopsy photos show only a single impact site on Nikki's head and only a small amount of subdural blood and brain swelling at that part? Has any jury heard arguments or evidence to that effect?
I would have to check the original transcript to accurately testify.
Has any jury heard any arguments or evidence to the effect that Nikki had potentially toxic quantities of a drug, Finnegan, in her bloodstream at the time of autopsy? And has any jury grappled with or interacted with the facts that those drugs now carry an FDA black box warning against prescribing it to children's, yes, Nikki's age? The black box warning from the FDA is directly applicable to children that were the age of Nikki at the time. Has any jury ever interacted with or heard arguments to that effect?
Respectfully, sir, that was brought up during the Article 11.073
I'm asking if any jury,
so that's the of a judge, not in front of a jury. So it was not known at the time.
Were in her system at the time?
I
of
would
autopsy?
have to check the original trial transcript that was in front of a jury.
I have several more questions along the lines of this, but I don't see the value in them, and we're running up on time. You mentioned in your testimony a minute ago that Nikki's body was lifeless, blue, and limp. As a father of 4 young kids, this is heartbreaking to hear of any child. Are you aware of the episodes that are documented according to witness testimony in her medical history of previous episodes of breathing apnea where she also presented at the hospital with those exact same symptoms?
The maternal grandmother testified to that in the original trial, if I remember correctly, when she was younger.
So you are aware that at previous times in Nikki's young life, she had presented to the hospital lifeless, blue, and limp?
According to the evidence presented at the original trial, yes.
Do you believe those were the result of abuse?
What was a result of abuse?
Her presenting at the hospital lifeless, blue, and limp from previous episodes with breathing apnea.
I'm not in a position to speculate as to that.
But you wouldn't dispute that she had showed up to the hospital with similar presentations in the past and that there was never a finding or adjudication or allegations of abuse. Is that correct?
I believe that her presenting with sleep apnea would appear different, but I would have to go back and look at the evidence that was presented at trial.
It was not sleep apnea, breathing apnea.
I apologize, I misspoke.
That's a significant difference. Okay, I'll wrap up. You set the execution date. You don't know when. Do you know why?
Because that was the next step in the course of the law.
Were you satisfied that a had been committed?
Yes.
What was that based on?
The totality of the evidence at the original trial, post-writs that have been filed, and hearings that have been held.
Just to be clear, you're referencing evidence that no less than 30 times in this hearing you have said that you have no knowledge of at the moment. Is that correct?
I'm sorry, sir, what was the question?
I'll move on. The justice system can get things wrong. Is that correct? That's possible?
Just like any humans, police officer, priest, yes, that's possible.
Is there any chance in your mind whatsoever that a murder did not take place in this case?
Based on the totality of the evidence, as I've stated, a murder took place here. Mr. Roberson took the life of his almost 3-year-old daughter.
And you have 100% certainty that that happened? I'm not asking what the legal standard is in court.
What was the question?
I'm not asking what the legal standard is in court. I am asking how certain you are, having reviewed the evidence, which you must have reviewed because you requested an execution date. What is as a percentage, what is your certainty occurred in this case?
I trust in the legal process that has the safety nets and reviews to do the checks and balances to make sure everything is right, and I believe that that did occur here.
So to be clear, you trust in a process that one moment ago you admit sometimes does fail.
Driving chains, dismantling fear, failing justice, the movement we revere.